Hi, my name is Rusten Hurd. I'm an immigration lawyer and I focus on E-2 visas. And today we're going to talk about the three most important trends in E-2 visas for 2021. Jumping right in with the first trend for 2021 for E-2 visas, that is employment creation for U.S. citizens. Back in 2017, the Trump administration had released the Buy American, Hire American memorandum, which indicated that consular officers, as well as the USCIS, should look directly at job creation as one of the key elements in determining whether an E-2 visa should be granted. Now, historically, looking back over the last 15 to 20 years, I've had clients who have had E-2 visas renewed multiple occasions without the need to create a single job. The marginality requirement of the E-2 visa, demonstrating the ongoing viability of the business and the fact that the business was creating worth beyond just the investor and his or her immediate family, was sufficient to be able to make that determination. The business was profitable. It was essentially reinvesting into the United States. We could see the positive secondary effects associated with that. However, and it did take some time. It didn't immediately come into place in 2017. But what we have seen over the last several years is the increased import of job creation caused by that policy. And it is now well set in with the consulates that they're really looking for initially either if you have created jobs already, or what is your plan to create jobs and how can we verify that? How can we look to ensure that the job creation requirement now is fulfilled? Even though that's not directly in the regulations pertaining to an E-2, that proposal, that memorandum, I should say, remains in effect and will likely continue as a point of emphasis for consulates, at least going forward in 2021. So my recommendation to my clients is preferably to have one U.S. citizen hired at the time you file the application, or at least a clear plan to have that U.S. citizen working in the business and showing that it's necessary within that first year. Even though it's a 5-year plan overall, of course, we're submitting with the application for the E-2. We're going to want to show that immediate employment of at least one U.S. citizen and then generally at least another U.S. citizen over the 5 years of the business. Of course, different businesses are going to look at this in different ways. But job creation for a U.S. citizen is certainly the number one area of focus that I discuss with my clients here as we move into 2021. The second area of focus for E-2 visas is irrevocable commitment of funds. The number one issue I see with clients is talking about ensuring that those funds are at risk. The unique nature of the E-2 is that it is not merely an idea to start a business in the United States. It's not a plan on paper. It is actually required to be the execution of a business in the United States in order to obtain the visa. And so really there are two ways to go about doing that. One is the purchase of an existing business, and the second way is starting a new business from scratch. Okay? And so many of my clients want to know, can I utilize an escrow? And can I put those funds in the escrow contingent on the E-2 visa being issued? And if it's issued, then great, the funds conveyed to the seller. And if they don't, then I get my money back. Okay, so we're going to try to obviate the risk associated with the business purchase from an immigration standpoint. The answer to that question is, from an immigration standpoint, when you're purchasing an existing business, you can absolutely do that as long as the sole contingency is the E-2 visa. If there are other contingencies such as due diligence, the amount of inventory, or other things listed, that's not going to work. But as long as you're purchasing existing business, the existing business meets the other criteria associated with the business with the E-2 visa, then that is a perfectly fine way to go about proceeding to get your E-2 visa and protects you from a risk standpoint in the event there's some other issue where your E-2 is not issued. So an escrow works for the purchase of an existing business. But with a new business, an escrow is these days just not going to be a viable option. You're going to have to demonstrate to the consulate that those funds have been irrevocably committed. Those funds are truly at risk. What does that mean? Well, the funds cannot be just sitting in the company bank account. The funds either have to have already been spent towards the business, or you have to have a binding contract, such as a purchase of inventory, equipment, etc., that is clearly going to be used for the business. And I don't think a contract in and of itself is going to be enough. Really, at least some of those funds, and it depends on the business as to exactly how much, but some of those funds are going to have to be spent. You're really going to have to show the consulate that the funds that you've invested in the business are truly at risk. And you can't just pull them out the day after you get your E-2 visa. They want to know why you can't just pull them out after that. It's actually a question that many of my clients have gotten at a variety of consular posts. So keep that in mind. You have to show really that the business is ready to open its doors, or it's already open right after you are issued the E-2, and that those funds are irrevocably committed to the business. Finally, the third area that's a key for 2021, just like it's been a key for 2020 and for years past, is the substantial investment requirement. And I would say the number one question that I receive from clients is, how much do I have to invest? And the answer to that question remains that it really depends on the business. Now, historically, you look back a decade or so, and you could get an E-2 visa for a very low investment amount if it was a service type business, something that really requires a lower threshold for the startup capital. However, as we sit here in 2021, I really don't feel comfortable advising my clients to utilize that lower amount. Sure, it's possible that you could get a very friendly officer at the consulate, or if you're changing status through USCIS, that would be willing to give you the benefit of the doubt. But there is a much higher risk associated with proceeding with a lower investment amount. Now, the regulations indicate that the investment amount necessary has to be substantial relative to the type of business in which you're investing. So if you are investing in some type of professional services company, for example, financial services, or sometimes I have internet-based companies, essentially other companies where there's not a large amount of initial startup capital required, I think they are going to take that into account. But I think there's somewhat of both a subjective and objective analysis done, generally speaking, where, okay, the startup capital is less for this type of business, but there's still some type of objective requirement where, although historically you could get E-2s at less than $50,000 in terms of startup capital, these days I think that's going to be really difficult, and I would be extremely concerned if the investment is going to be less than that amount. Certainly the rule of thumb for most businesses, if you are an owner, 100% owner of the business, capital investment of about $100,000 is generally going to be sufficient. Now, again, if it's a business that is necessarily going to require larger than $100,000 in order to successfully start up the business and viably operate the business, or alternatively, if you're going through a consulate that is a more difficult post, there are several that have a heightened requirement, although that is not found in the regulations as a fact of life, they do require more, then that is going to be different. But generally speaking, if you are the sole investor and the business, we can document that the business doesn't require significantly more than $100,000 or to start it up and get it going, then that is going to be sufficient. And that is where the capital requirement overall has been. I don't think there's been a lot of change to that. What I think the change has been over the last several years is that some of the lower threshold businesses where certainly you've heard stories of foreign nationals that invested $15,000 or $20,000 and they were able to get their E-2 through that. And I'm not saying that couldn't be possible. It's theoretically possible it could happen if essentially everything fell your way. But my personal experience has been from reviewing decisions from consular officers that it seems that these days they are requiring. Now, I don't feel comfortable filing for less than at least 50,000 in terms of startup capital, and probably going beyond that. But again, it does depend on the business. It does depend on the specifics. So those are the three areas of primary focus for 2021 that we went through. I would encourage you to please, if you have questions about the E-2, please drop them down in the comments. I'd be happy to go through and